that will reverse rulings of the court. That for me amounts to that. Or government decides to withdraw funding to the judiciary and crippling it financially. That for me is the attack. The framers of this constitution did not put Article 146 in the constitution for aesthetic purposes or for decorative purposes. It intended that one day a judge would misbehave.
Chief Justice remover and I say Chief Justice Yasakino. Controversies bebree na asarande wo ho. MPP fo binom ene Ghana fo binom say Yewra John Mahama ene na aban aseti president ato ho. Se ye kan president a ekire se why bibia se aban foforo bi nso ba na se ochene bi no obi nso betime gina so na why bi. Sounds na eye NDC fo ka se dabi anya NDC fo nkwa Ghana fo binom so ka se dabi maame no oteso no na behave as if say Supreme Court honum ne dia because so be have birth certificate issue na e ba ya o say eno nche say we Ghana ni sa ne manema no what I say abusuafo Ghana fo bebre chro madwen but NDC legal council no omo leader Yewra Amaliba what I say Amaliba de nsembi aba monti wa clash one Kofi Bentil, I think so. Yeah, Imani Africa na bibi sa amfa ncheme. Omo president, yes. Omo clash on Alfred Okansi. The show no so with TV3. The key points. Yenti nse ni bi yakoba ebeto so.
Let's start this way. Even before we go, 2 quick comments. I've seen a story on City News that says that Ochribefi says he will not contest. So I believe that with City News being quite a credible station,
we can
means
go
that
with
Ochribefi will not contest the next election. So that's good, all right? Then number 2, so to start this one, Mr. Okansi, as we speak, and you know earlier in the week I did an interview on this matter. It's on YouTube, okay? True. When I answered Sofa Ekufu, our beloved Sofa Ekufu, yes, Antua. Please, people are still going to jail for stealing chicken, plantain, cocoyam, goats, etc. Article 17 says that we are all citizens, equality before the law. Let me tell you, this matters that we've been trying to be polite, right? By not calling what the ex-Chief Justice did by its proper names. We've been trying, we've been polite, but the more you get the way Kofi is going, then the more we are tempted to actually call those infractions by their names. Abuse of office. That's corruption, please.
Abuse of office?
Abuse of office and corruption. That is what those things are.
How?
Please, no, let's stop. Let's stop this. It's not good because, look, I thought that is very clear. Because of what Justice Torkonoo is done, she served the country. You see, we always have to read the mood of the nation. What did you show? 337,000 for per diems and what? For per diems. Look at the audit report. What did he say? The daughter got $10,000. 10,000. Kofi, who appointed Torkonoo's daughter to take $10,000? You know how much? Even today, $10,000 is 105,000. I can tell you, check Ghana Statistical Service. Millions of our citizens, not even thousands, so millions of our citizens don't earn $10,000 in 12 months. $10,000. So if you bring it to Ghana, it's 105,000. Please, can we divide 105,000 by 12 months? You see.
You ask me who appointed her. Who paid that money to her?
The accountant. Who asked
with what authorization did that accountant pay that money?
Of course, with the Chief Justice authorization. What are you talking about? Please stop playing ostrich. You think the accountant can tell Chief Justice that I'm not paying you? Exactly.
So if you're an accountant, if you're an accountant and the Chief Justice comes, you ask me a question. That's why I came.
Yes, the more you do this,
so you make your presentation.
Okay, the more you do this, then the more it's unfortunate. It's unfortunate. 105,000 Ghana cedis divided by 12. Then you see the gravity of millions of our citizens don't get that. They get up and go to work 21 to 22 working days a month. The people sweeping, the Zoom Lion sweepers, all right, the security men, so many farmers, lots of people don't get $10,000 a year. That's just one trip. Then the husband also got $6,000. Look at the ticket. We spent about $100,000 on the Adam Amiga, this Torkonoo, the lady, the daughter, spent on the husband. Please, let's not trivialize these matters. And that's how come when Justice Kufu said we are trivializing the office, I said, oh, my beloved Yasantua, did you really say this? Because when you say trivialities, money that a lot of our citizens don't see in a year, okay, 105,000, that's even just one trip, 105,000, that's the one trip. I've not added the husband soon, now I'm ready, 105,000 divided by 12.
750
a month. Check, even Ghana Statistical Service, check. The last time they did somebody can Google it. Even civil service, when you go in there, it's only they said over about 90% of our citizens don't earn 8,000 a month. Please, Kofi, look at it.
You keep calling me.
Yes, I want to invite you. The money is gone.
Martin,
and
that's not the issue.
You said it's not significant.
The issue of whether people are making... Look, do you know the kinds of money our leaders spend on tea?
Excellent. That's
the issue. The issue is not that it's 8,000 a month. The issue is...
We're going to get... I think that point you made...
So I'm not coming to that point. And that is where we are making the mistake. We all know. Look, this morning I referenced the Cecilia Dapa cash. Okay? Mustafa Hamid is gone away with 200 here and his bunch.
Please, it's an allegation.
Oh, yes, so I'm free to mention it. If it says it's false, it should bring its evidence.
Qualify.
280 million Ghana cedis. The Mustafa Hamid corruption case. 280 million.
The allegation is investigated.
Yes. No, it's in court.
Okay, yes.
Yes, it's in court. So I believe it. I believe what the OSP is. So I'm entitled to say so.
Right.
Listen, let's make that distinction. I haven't said he's guilty. I'm saying from the facts, money is gone. As to whether it constitutes a crime or not, that's for the court. But it doesn't stop me. Yeah, Mr. Can say it's fine. It doesn't stop me from saying the money is gone. Cancel, it's not true. The money is gone. I can use Article 286 to say that Mustafa Hamid, why and the Amoa and the rest, why did they take that money? Is that their monthly salary?
No.
Is that their fuel allowance? Is that their entertainment allowance? It is not. So once that money is gone, I can comment on it. I have not said they are guilty of a crime. So Kofi, yes, we are all bemoaning it. That look, yes, it's good because that will make the argument stronger. We all know that look, when ministers travel, you hear unaccountable impress, etc. So I even mentioned in Tuesday's interview that so we want us to have a full debate, council. That so when our ministers travel, how much do they take? That thing they call unaccountable impress. How much is it? So we know that politicians are chopping our money. So if the Chief Justice also wants to chop some, use the rules. But why you don't use the rules, not that we agree, but what I mean is that once you've gone and to do something and it's against the rules will apply. Look, the thing says that, I don't know what makes it rocket science. The policy, and it was there even during Yasantua's time, because when she went to testify, she was asked that when she was there, she was shown the document. It says, when you are going on a private visit, please use the state security. Because there's a professional trained for that. State security, that's very clear. Justice Torkonoo went on 2 private trips and didn't use the state security. One of them, she went with her daughter. The daughter made $10,000, which millions of our citizens don't make the whole year. That's one trip. The next one, she went with her husband, $6,000, right? Which also millions of our citizens don't make. So this is not trivial. Not like what our beloved Yasantua.
It's wrong. We are saying it's
wrong. Yes. So that is it. Just look. I know people are buzzing my phone with the reference to this Angela Rayner, UK Deputy Prime Minister. She resigned because she failed to pay tax of about $40,000. She resigned. Yesterday, she had to resign. She had to resign. You see, so this thing that we're trying to justify, the more we do it, then it's like, okay, we are not ready for the reset agenda. No. So to be clear, the rules are there. And even when you go, you dig further, there isn't anything like Justice Torkonoo is not aware Look, when Sophie Kufu was asked during the proceedings that she see that when a chief justice is appointed, there's an appointment letter, and inside that letter, there's per diem for travels, etc. It turns out that what is in the appointment letter is at variance with the policy this very policy that they set up there.
Which is very normal.
So why would it be at variance? You go into office, viewers, let's go step back this way. Yeah, and you know we are saying that the president in our next constitution should not choose chief justice, Supreme Court justice, etc. We started making
you want that power taken from the president?
Yes, it should be taken. Article 144 clause, let's just say 144 should go. The power of the president to appoint high court judges, court of appeal judges, Supreme Court judges. No, let's do an independent judicial council, not the type in Article 153. Specifically, I mean, over there, when you go there, you see that the president controls at least seven appointees on the judicial council directly. He appoints 4, appoints an attorney general 5, the police representative 6. The police representative will listen to the president. The army representative will listen to the president because the president is the commander-in-chief. So about 7 persons on the judicial council are not independent. They are not independent, even some of the judges to some extent, because the judges are also appointed by the president. So the judicial council is not fit for purpose. So we change the judicial council, then we also take away the powers of the president to appoint judges in Article 144, right? So we do this, then we get more independent justices. So the point, and not just you, of course, we are making the point. So you see that there's an appointment letter, a chief justice is appointed, there's an appointment letter, and it mentions what are the per diems, etc. You come into office, then you set up a different policy. Now, so ipso facto, we are already in the realms of illegality. If you think the president should not be giving you terms and conditions of appointment, say so, fight it. I'm not taking this letter. But you don't take the letter of appointment, then go into office and go and do something different. Because the letter of appointment is a contract. Once you accepted it, it's binding until it's been set aside. So if you go and do something else in office, it's an illegality. So in cross-examination, Ansah was asked, do you see that the per diem stated in the letter of appointment is different from the per diem in this very policy? She says, yes. Ansah was asked in cross-examination, when you're going on that one, page 22, when a chief justice is going on a private visit, private trip, the chief justice must go with a security. She said yes, she agreed. So the question is that once Justice Torkonoo went with her family relations on private visits, isn't it a breach? It's clear beyond that. This is what in law we call no further inquiry. No further inquiry. The thing is as plain as white. This is open and shut. Open and shut. And yet today we are being told that there's not enough evidence has been adduced, it's not clear, etc. No. And let's shift. You see, these matters we are talking about, they didn't start today. When it comes to what constitutes stated misbehavior, look, as far back as 2006, in the Ejechum case, listen what the Supreme Court said when it comes to the transfer of the judge. It says this that a ban and Justice Sophie Kufu Ansah concurred. Though what I'm about to read, Sophie Kufu concurred. Wood CJ concurred.
She said even though she concurred, then she has over time been reflecting on that particular Frank Ejechum case, and she's seen the flaws in the position that she took. And reason why she thinks that there has to be some reforms in Article 146 specific to the process of the removal of the Chief Justice.
And because, Marty, you keep mentioning me, nobody is justifying what has happened. I have a mountain of problems with the kind of profligacy in Article 71 appointees. The kind of monies they spend there for all kinds of things. Excellent. So I'm not justifying it. Yes. What I'm saying is, whichever side you are on, we need to be very sober about this. And you see what Okansi just said. I think we need an Article 296 application to 146. There must be even further clarification. You know, in other places they call it high crimes and misdemeanors. It is intentionally left vague. High crimes are like murder. A misdemeanor could be a traffic offense. But when you come to some of these, my point is, if we don't over time tighten it up, then it will become a crude tool that anybody will use against their enemy. And I think we are getting there.
Oh, that one we all agree.
We are not justifying this.
Yes, we all agree.
I'm saying we need to be very sober.
That is why we are saying that.
Because we've seen Charlotte, we've not seen this one, we will see others.
Yes, and that's why we are saying that in the new constitution, Article 144, the president's powers and Article 144 must go, so that there will be a more independent judiciary. His powers under Article 153 must also go, so that we get a more independent judicial council. We started making this. I joined.
You see what I wrote about that?
Yes,
I agree.
He said, So let's read a bit to show what the Supreme Court says is stated misbehavior. At page 775, this is what that bar says. I think that the plaintiff's argument on this issue is founded on the fallacy that a Chief Justice's conduct in the administration of the judiciary can never ever be construed as a stated misbehavior or incompetence within the meaning of Article 1461 of the Constitution. Other justices of the Superior Court also have administrative responsibilities, such as the supervising High Court judge or judges representing the judiciary on the General Legal Council. I believe that it would be dangerous and not in the public interest to uphold a proposition in relation to all such judges that their administrative acts cannot ever be the substance of a charge of stated misbehavior within the meaning of Article 146. As far as the Chief Justice is concerned, I think it is reasonable to link his conduct of administrative responsibilities with his position as a judge. Then let's go on. 776, it says, justices of the Superior Courts, justices of the Superior Court are required to adhere by certain judicial ethics, which can be infringed by the conduct of a Chief Justice in the performance of his administrative acts. It is therefore unacceptable to exclude a priori all administrative acts of the Chief Justice from scrutiny, as possible evidence of stated misbehavior in his capacity as a justice of the Superior Court. And you go on and on. So they went on and on and on to mention issues of bribe, etc. That if, for instance, it were established that a Chief Justice was taking bribes in exchange for transfer decisions regarding justices of the lower court, would this not be stated misconduct as part of the a justice of the Superior Court? And you go on several other pages. So the Supreme Court has been very clear that once the conduct goes against our laws, it qualifies. I also agree that going forward, maybe we can categorize the conduct minor, major. We can do that going forward. But right now, the law is the law. The law is the law. We have not categorized them. The Supreme Court says
with different thresholds.
Exactly. We can do that going forward. I've written that on Facebook that we should do. If you take like CI 76, the police service regulations, you see they've outlined what is a major offense and what is a minor one. So we can do. But right now, the law is the law. And you see, Justice Torkonoo knew about it. At her vetting, she said, we should take away the powers of the president to be involved in this whole process. But when Justice Torkonoo took office, I didn't see her invite us to any symposium to come and debate this matter. I didn't see her table any constitutional amendment. So, I mean, what can we do? So right now, we have to apply the law as it is. We cannot change the the standard. And you see, but sometimes, let's mention these things. Let's not forget, I'm not being for only this. We also know other documents that have been thrown out in public. The contract with her daughter, the Chief Justice's own office. Her daughter was the one doing decor. How? How can the Chief Justice's daughter do decor?
The treatment of that. So again, you see, we have a wider problem. My issue is that when you leave some of these things,
A quick intervention. Consider
All right.
let's move on. Yes. No.
yeah,
The
but I'm
contract to
saying,
a daughter.
I agree. The treatment of that is the issue.
No, I'm saying that they are
Okay,
both.
and it's not an isolated matter. So we need a holistic dealing with this matter. My worry is that you leave all of these things in a certain discretion way. Now, the framers of the Constitution did not intend that Article 146 will be used this way.
Oh no, Kofi, these are very serious.
No.
These are serious.
You are not getting me.
This is corruption and abuse of
You are not
office.
understanding me.
This corruption and abuse of office.
You need to understand me.
Gentlemen, hold on.
Using public office for private gain. That's corruption.
Okay, so I want Kpebu, you conclude the point because the point you're about starting the Bentil is a substantive one. You are now getting into the intent and the mindset of the framers of the Constitution.
We're not sharing their intentions.
It's another point that we're going to get into as to whether really that was the intention of the framers of the Constitution, specific to Article 146. You say that the application now is not what was the intention of the framers specific to Article 146.
I believe.
Why is that? Quickly.
Given that the office of the Chief Justice is such a high office, and they are the supervisors of the realm, 146 is there to make sure that a person who definitely by their conduct or whatever does not merit that office will not remain there. But in leaving it the way it's been left, again, you have a situation where so much the width of the discretion is like that it can be misapplied for a premeditated intention to remove somebody, and then we'll find all the things to put in, including things that auditors also should do. So my view is, I agree with Martin on that we need to tighten this a bit more. And all that I'm saying is that, look, what has been done is done. And it is, Justice Torkonoo said the law is the law. The law as it is now has been followed. But the question is, are we in a race to the bottom? The answer is yes. If we don't fix it, we are not going to do better in future. And anybody will come with any reasons, misdemeanors or whatever it is, and remove a Chief Justice.
But if you clearly stated in 1461, it gives the three reasons and the grounds on which a Chief Justice can and should be removed. That was the intent.
No, the intent is that you should not have a Chief Justice misconducting themselves at the same
In those three instances.
Yeah, but that's why we have Article 296. There should be further treatment in executing somebody's premeditated intention. That's where the problems are.
So
and if we don't deal with that tomorrow, we'll have a problem.
Your view is that this, and I'll have you conclude on the point. The penal consequence, in your view, should have been possibly a refund and not as one of the bases for her removal.
Absolutely, if this is the issue.
Okay.
It's an audit issue.
Yes, Mr. Counsel, let me repeat this argument. You know, we've said that there are three professions in this world. There are only three. Law, prostitution, and what? Divinity, the pastors, right? And amongst that, law is primus inter pares. So we are held to the highest standard. We are held to the highest standard. So yes, I get you. An ordinary civil servant may be asked to refund, etc. But for the citizens, when that concerns a judge, the judge applies the law, putting us on the straight and narrow. So the least thing you find that the judge has left straight and narrow and is on the this wayward path, the citizens lose confidence in the justice
All
system.
judges or this one alone?
Oh, so this is the example that's come out.
So is that rule for all judges?
Which one? This one?
No, what you're
Yes.
saying that a judge has refused to hear me in court because I was not wearing a white shirt. All right? And denied my client, the necessary representation.
Yeah, but those are the rules.
Is that rule correct?
Yes, it's a rule. It's a rule that don't go to. They say, oh, the legal. They say one way law school they gave us. They say they prescribe. I can't go to court with this.
No, wait.
You don't use blue shirt. You can't use a blue tunic. They say white.
Wait.
That's a prescribed uniform.
Wait. Do you know? Sorry, we are going there. No, hold on, just 1 minute. It is established that you should not visit the sins of a lawyer on their client, right? Right. And when in almost every high court, there is that laxity. That's the point I'm making. And that was my first time in that court. and I was very well dressed. And the person says, "This place you can't do this." I said, "Oh my lord, next time I won't do that."
The Supreme Court, they sack people
You are
all
not
the time.
getting my point. Listen
okay,
to in the Supreme Court, that is an established rule. No, I'm coming because he said something. and
Yes.
we are educating the public.
It's
He is saying
important.
law is the greatest profession. I don't agree. But if he's saying that these rules must be so stringent, and I'm saying, should it be only against the Chief Justice or all of us lawyers?
Well,
And to the extent that look, so many atrocious things happen in court. All right, my boss is here. Okay, are we going to apply this high-handed rules to ourselves, or we are going to be measured in how we deal with things? Because
Okay,
look,
I
nobody's
think
perfect.
that you've gone on about how high-handedness you think it is,
I think it's a bit excessive.
and the fact that yes, this is a very high threshold
Somebody was
applied
drinking wine
to what you describe as
online.
a very, for the lack of a better expression, not too grave a mistake to warrant the removal of a Chief Justice.
Yes.
The concern that Lawyer Kpebu raises is the integrity attached to the office,
Yeah.
right, of the Chief Justice. Can such an act be excused and described as not too grave to warrant the removal, taking into consideration that office and what is expected of the office of the Chief Justice? Lawyer Kpebu, can that be done?
No, say it again.
I'm saying, can this act,
Yeah.
as she has been flagged
Yeah.
to have been involved in,
Yeah.
be described as not grave enough to remove?
Certainly not.
The Chief
Certainly not.
Justice.
That's the very question we are answering. That it cannot be. So far, what has happened? The other names for these things that have happened is corruption. Corruption, abuse of office. That's the other names. Misappropriation of 337,000 on foreign travels. Yes. Because the money is went to the daughter, went to family relations. So using public office for what? Private gain. Please. Yes, maybe we are forced to do it. I don't like, I've made noise here, ad nauseam, that we should allow her to resign. Allow her to resign. Yes, I am influenced by that largely because I've seen the executive take more. This is chicken feed when you go to the ministries, etc. And that's why I said at least we should have allowed her to resign. Then we can have a national dialogue on these things and especially streamline what happens in the ministries. They travel business class, etc. The president said he had banned first class. Citizens came out and said, how many airlines even do first class? Then it looks like that debate went quiet because now does it mean that our ministers are doing economy premium or they are doing business? If they are doing business, maybe we should revisit it. So you can see that it's the inequality that is fueling all of this. There's a lot of inequality in the system because even when you Google the pay disparities I was mentioning, look, when you Google pay salary, civil servant, they say, just Google it. You see, it says average public sector salary hits 2,594. Okay, this publication is 17 February 2025. That's on graphic online. Hey, by the way, please, in case you haven't seen, I understand the story that the city is the worst performing currency. It's false.
Yes, it's a matter we'll deal with.
It's false. Later. Okay, but when you Google this, you see, so call it 2,600 Ghana Kofi. So you see the point I was making. So if 8,750 per month, if you divide 105,000, okay, it's gone into somebody's pocket. It's a serious matter that involves millions of people.
That's why
so
the
nobody.
Article 71 should be deleted.
Yes,
that's a different matter.
I mean, that's why it's fueling this whole debate because you see that for decades, our citizens have been very upset that the public servants and the politicians are feeding fat on the public purse. It's creating too much disquiet. That's the thing. So that's what's been behind this, and that's how come nobody would be here to say that the 337,000 Ghana cedis is no money. And that's where Yas Antwa got it wrong. And you see that if you go into the audit report, you find out that, unfortunately, it's not Justice Torkonoo alone who has breached this rule. Her predecessors also did. Yeah, the report.
Other Chief Justices?
Other Chief Justices did. It's shown. And some were asked to also refund. The audit report... No, not at the committee, but in the audit report. The audit report that first flagged this matter, a certain Chief Justice was also asked to refund.
So why not this time?
Sorry.
No, but this is another
And that Chief Justice is left office.
So, yeah, let's
Right? Yes, they said that Chief Justice is left office.
That's what I'm saying.
That Chief Justice in the report. Please just get the Auditor General's report. You see, that Chief Justice is left office. And then it further shows that it even when that wasn't the first time, others who were involved. So you see the accountability this case is solving. It means that every Chief Justice henceforth will be careful. The next Chief Justice coming will be extremely careful, knowing that the listing that Chief Justice will be out. So that's accountability. So this case is rather strengthened us. And let's always remember, Angela Rayner, she didn't pay tax of $40,000. She resigned. She resigned straight. She didn't even wait. She even referred herself, Deputy Prime Minister. She referred herself to the Ethics Committee, the Ethics Advisor. And then when the advisor came out and said, yes, you didn't intentionally evade the tax, but you've broken the rule. Out of the door. And here we are dragging it and saying which hunting, yes. Public in the executive, they are spending our money rough, right? Or got the chopper nyafu. So let's solve that one too separately. But we can't say because when you go to the executive, they're able to get unaccountable impress and they are chopping the money rough. Then even where the rule is very clear, we should just sweep that under the carpet. No.
But is there any confusion really and lack of clarity about who the former Chief Justice could travel with and how much per diem could be
there? There's no confusion at all. The thing says, the policy, it says that when you are going on official trips, that one, you can go with your relation. Okay, the spouse, the daughter, yes. But when it is a private trip, go with the state-appointed security. It's obvious. When it's an official trip, when you go there, they provide security. Provide security. But when you're on a private visit, they don't provide security. So use the state.
The state pays for the security. Okay, but this is what she said about that proposal you made. And Ansah Asare, I come to you and then lawyer Abraham Amaliba. On the proposal of she resigning earlier, this is what she said. Take a look.
Yeah. Resigning or retiring while Article 146 proceedings are being conducted to remove a judge is not an option any judge or public official can even have. There is a decided case on the matter by the Supreme Court. The suit number is J6/02/2019. Again, no one has the authority to walk away from proceedings started by the state. Judgment can be entered against you because you fail to defend yourself. And a judge who resigns or retires would still lose all entitlements that they have worked for because they failed to defend the claims and resigned or retired while the proceedings were still going on.
That was a concern, Kpebu, that if she had taken that option that you proposed, she would have lost all her entitlements. But then again, with this that has happened, she still would face that same consequence of losing her entitlements, correct?
Yes.
With the removal.
Yeah.
She will lose all her entitlements.
Yes, she's lost. She's lost all her entitlement because of the stated misbehavior. But you see, if she had resigned, what I was saying was that not just resignation, and thank you, Senior Kpebu Ansah Asare is here. We hold the same opinion. If we had allowed the resignation, what I was saying was that, you see, elderly statesmen could have come together and prevailed on President Mahama to say, look, let's accept a resignation because she's worked hard. And we all know that, yes, this money is chicken change compared to what the executive do to us. We're here when the Akufo-Addo was flying in the sky, bathing in the sky, Sewa, Broni, etc. Right? Ministers, look at Cecilia Dapai's money. Yes, so when you analyze it from the rot in the public sector, this is certainly chicken change. That's how come I kept saying, no, let her resign. But she didn't ask for it publicly, for people to step in, right? Yeah, she didn't work hard at it. But as for the committee case, it was clear that she was going to lose because there was nothing she could do to win a case. The thing says when you're going on a private visit, go with the state security. Simple question. When she went to Tanzania, did the policeman go with her? No. This one, what further evidence?
Okay.
What further?
I need to. I'm gonna. Let me just.
It's important to say it wasn't open to her.
No. Oh, it could have been done. It could have been done.
Okay.
If we had all
against the law. Hold on.
Oh, it could have been done.
That's all right.
I
So you see,
it could have been done.
the point is clear about what Kofi Bentil takes a path that he's not justifying what has happened. There's wrong that has been done. How the wrong is to be remedied, or who should carry the burden of that wrong, is one question that he raises. As to, yes, even if it was the request of the former Chief Justice to have been paid a certain amount, who was to dispense that amount, even if it was captured in a particular policy? One. And secondly, the fact that this penal consequence is too grave to warrant really this particular sacking that we have seen. I want to find out from you if this sacking is a consequence that matches the offense that has been established of stated misbehavior in this instance.
Thank you. I think the law is the law. And when it comes to sanctions, the law does not thrive on an assumption that it should be commensurate with the offense. Sometimes, thresholds are set, sometimes not. So it depends on the status and gravity, of the offense. In this case, I would say that for somebody who has worked for over 21 years, giving dedicated service to the nation, it will seem at first sight, to be too punitive, to lose everything. A way could have been found. We could have circumvented and say that, well, ultimately she must be removed. But looking at the surrounding circumstances and the 337,000 and all that, and the fact that the president is the father of the nation, something could have been done, and say that, well, rather than go home persualess, we would retire you. You can, enjoy all your benefits, including your retiring benefit. That could have been one way out, or, well, you've done it. We'll sanction you, but at the same time, we'll allow, the constitutional provisions to be implemented in your favor. So that's my immediate reaction. Having said that, this whole Torkonoo CJ removal process, I would say that the former Chief Justice, Torkonoo, was a victim of many circumstances. A victim of many circumstances. I can outline, say, 5. The first, was the president's meeting with the lawyers, the NDC lawyers, and expressing a view. Initially, my take on the president's meeting, then the NDC's presidential candidates meeting with the NDC lawyers, was that yes, I mean every presidential aspirant, will say this or that, and as Martin Kpebu said, they can make, political U-turns. Nobody will worry himself or herself about that. So that's, the first. The second, the absence of any definition in the Constitution on what will amount to stated misbehavior. Because the framers of the Constitution thought it desirable to outline, certain everyday, words and to assign meanings in the Constitution in Article 295. But with regard to stated misbehavior, the framers, didn't say anything and let it ajar so that it will depend upon interpretation, and judges, are also, ordinary mortals. When you give them the chance to interpret. So you see in the Frankejechum, and AGN Bright Akwete case that, the retired Chief Justice, Professor Dateba, went to lengths. But still, if you read, the judgment, and, luckily, Kpebu, has walked us through pages 766 and 767 and all that. You see that even after outlining examples, our respected, Justice Dateba still left it open, meaning that the categories are not yet closed. So day in, day out, other, things could come in which will qualify as stated misbehavior. So that's the second, the absence of any, definition to guide the court. The third, self-induced, was the nomination and subsequent appointment of Torkonoo, out of 10 by the former president, which, was severely criticized, but the former president, didn't heed, any call to take a second look at that. For me, that was a catalyst,
That there were other senior persons.
Sure.
Than him.
Taken out of 10. Then the fourth circumstance of accident, the fetish that we are making of our precedents. So the Frankejechum stood guard over any remedial measure, favorable measure, for Torkonoo. Stood guard because the Frankejechum thing has interpreted Article 146 holistically in accordance with the canons of interpretation, that in interpreting or construing a provision in the statute, you do so, so as to make a consistent meaning by looking at the entire. So you don't merely look at Article 146, 6 to 11 in relation to the removal of the Chief Justice, but you also go backward to Article 146, Clause 1, which will provide guidance on stated misbehavior. This is, what has caught up, with this whole saga of total loss. If in Frankejechum, the Supreme Court, had said, look, we notice first and foremost that a Chief Justice can only be a Chief Justice, if he has served a certain number and being appointed from amongst, the justices of the Supreme Court. The question is, what if the Chief Justice is not coming from the bench? Would Article 141, 146(1) apply to such a person? Because the person, wouldn't in the first place have been a justice of the Superior Court upon elevation, to the high office of, Chief Justice. So the Supreme Court in Frankejechum, I think missed the point when they put the two together and said, by parity of reasoning, since, you can only be a Chief Justice, if you are a justice of the Superior Court, and therefore whatever affects, your position or status of Chief Justice, must relate back to your status as a justice of the Supreme Court. This is where the harm is. It's a misconception because Article 146 Clause 9 refers to in each case. So the Supreme Court should have segregated that you may be a justice of, the Supreme Court. If we are looking at your exercise as a CJ, yes, Article 146(1) says stated misbehavior, of a justice of the Supreme Court. Therefore, we would, divide into two, limit ourselves to justices of the Supreme Court, and then limit ourselves to the CJ who is being removed. If they had, told that line, we wouldn't have a situation where, it relates back
to the,
when the Constitution says there shall be no retroactive legislation, but you are interpreting a provision of the Constitution retroactively. I don't think, their lordships were right, insofar as they did that. And that is, what has affected former Chief Justice Torkonoo. Then the fifth, self-induced. Why ask a daughter to be a contractor in respect of some services in your office? She brought it, upon
decorating
herself.
an office.
Yes, she brought it upon
and the
herself.
furniture and all of that.
Yes. The other one, my good friend Kofi Bentil, was struggling, to align. You see, it is an audit issue, yes. But who is the head of the judiciary? The Chief Justice. Article 125, Clause 4 is clear. The Chief Justice shall be the head. So the buck stops on her desk. So whether an accountant or the auditor or whatever, any person, it is the Chief Justice. And she could not claim ignorance at desk. Being the head, the buck stops on her desk. So trying to claim ignorance that, as my good friend will put the meeting baby, and now they are there no buy, and I mean to me sign. I mean, it will lie in the mouth, to say so. Mm-hmm. So she must have known, the consequences, of signing. But after all, who approves and who disapproves? This is the Chief Justice. Mm. But the most serious of the stated misbehavior, from my point of view, was the attempt on her part to use a certain provision of the Civil Service Act to recommend the appointment of, some 5 persons, yes, as justices. That constituted judicial misconduct.
So that's it's serious, more than the misappropriation of this.
Judicial misconduct. See, if you look at the Judicial Service Act 2020, Act 1057, mm-hmm, as chairperson of the Judicial Council, she has the following powers. I'm reading. Section 7. That's stated misbehavior.
It is.
Stated misbehavior. So, members of the service and vacancy. Mm-hmm. Where there is a vacancy, that's Section 7, I'm quoting. Where there's a vacancy, A, under paragraph H, under paragraph B of subsection 3, or subsection 4, or subsection 2 of section 9, or B, as a result of a declaration under subsection 6, or C, by reason of the death of a member, the Chief Justice shall notify the President of the vacancy, and the President shall, in respect of a person who is appointed by the President under paragraph N of section 5, appoint a person to fill the vacancy. Uncle, she was trying to lift this particular provision, and under this wrote a letter to the President, mm-hmm, listing 5 persons. And when I looked at it, in Article 144, I felt, it amounted to judicial dishonesty. And for that, I was on air that, she should be reprimanded. And on one of your shows, mm-hmm, I did say that it could cost her job for trying to be deceitful. For me, that could have, and Kwekwaza, read into it and quickly.
That's what's coming to, because this particular one was captured in Professor Stephen Kwekwaza's petition, which was thrown out by the former president, Nana Donakwa Akufo-Addo, that it didn't constitute any grounds whatsoever for any misconduct. Mm-hmm. But this same concern has found favor in the sight of
Yes.
another
It's very
committee.
serious. Very serious. It meant that she was trying to procure the elevation of those 5 justices by fraud. And fraud vitiates everything. As a Chief Justice, she had, subscribed to the oath, to act in accordance with the Constitution. Why try to use, a provision not in the Constitution as a basis for appointment of, persons to the Supreme Court? I mean, if there was any stated misbehavior, I would just rely on that and say that, that was sufficient. I will not bother. But because, Kofi says that the 337 or this thing, I want to, tell Kofi, you see, if you admit to some infraction, and so by way they say, refund it, the high office of Chief Justice, it is not kitikiti. And the Martin, refers to our good friend, yes, Antoine. Former Chief Justice Sophia Kufu would always, usefully remind everyone, especially, law students going to take their entrance exam, that when you take the exam and the pass mark is 50, and you had 49, 0.9. Now, kase ka kitikiti nkaminya 50, and kitikiti in law doesn't exist. You either had a 50 or you didn't have a 50. So there's nothing like a kitikiti. Therefore, 337,000 will sound kitikiti and grating to the ear of civic-minded person. But the law is the law. Whether it is kitikiti or did she do what was in consonance with the Judicial Service Act? And she wears 2 hats, the hat of the judiciary and the hat of the judicial service, and both she contravened. So for me, I mean, it was, the committee was right, but we could also deal with the issue of retiring benefits, with some human face. Is it, equitable that she should go home persualess? Does the president have the power? And the president has, gargantuan powers under Article 72 of the Constitution, going to the clemency. So, I mean, the president has all that. Where I will fault the president is that he acted too swiftly when the report was submitted and he received it. As, our sages will put it, he could have, taken it home to sleep over it and obtain some advice from his pillow. I'm quite sure that something better than what has happened could have come out of that. But not too long after receiving the report, that is where I think, as father of the nation, he can take a second look at the decision.
But could he, because the specific dictates of the Constitution, Article 1469 specifically prescribes the action of the president after receipt of the report of the committee. He is bound to act. Could he have done any differently?
You see, that's why I said fetish. We become so fetish, that we cannot even wriggle ourselves out, of some quagmires. If you look at Article 146.11, Article 146.11, I believe that...
let's put that on the screen. 146.11 gives... the president also could have done otherwise. That 146.11 states, and I quote, the president may may at any time revoke a suspension under this article.
So, before reception of the report or the committee, knowing that this has happened, we're always on there suggesting that, look, let the Council of State members, let the Judicial
specific about the suspension, yes.
That's what I'm saying. Let the sages, let them meet with the president and former Justice Chief Justice Torkonoo in chambers, and then try to water down some of these things before the reception of the report, so they will know exactly, because he had the power to lift. Now, if he lifted it, then it means that he would have made the committee's work redundant, isn't it?
Well, yes.
So,
but at the point of the committee submitting the report, this particular recommendation you make has already passed.
Sure, that's what I'm saying.
Yes.
So if they had met, who says that if they had met, they couldn't, have worked something out?
Right.
They could have done it,
Okay.
but it was not done. Then 1469 says that in it. So when you get to 10, the president has been boxed into a corner, a point of no return, just to act, in accordance with the recommendations of the committee. So it is not a right for the president, whether he has a right or it's not just a right,
okay, but
it's also an obligation to act in accordance with the recommendation of the committee that probed the CJ. So we've given to ourselves a constitution that has become unfriendly, and then we are also bound by Article 1294 that whatever the Supreme Court says, therefore the Supreme Court previous decisions on this issue have become sacrosanct. So again, we cannot box ourselves out of it. So the way forward is for the entire nation. And now that we are reviewing, the committee for the review committee, to suggest, a middle path. When it happens that way, what path may the president chart?
Okay. Amaliba, just on the back of that position of proposal that Ansah Asare makes about how swiftly, in his view, the president acted. In fact, just to also put it in specific context of what the dictates of the Constitution specifically states, 14611 prescribes exactly what the president should do after receiving this report, which the president did, because it so then means that the committee had already made a recommendation of which the president acted upon. Could anything have been done differently?
Well, let me say that in truth and in fact, it's the committee that removed the CJ.
The 5-member committee?
Yes. What the president just did was to communicate that removal to the Chief Justice. But I'm hearing from the table here that we should have tampered Justice of Mercy because she had worked for 21 years. Who said that didn't happen? Who said? When it comes to the NDC legal team, I'm an integral part. My sources, incontrovertible sources, tell me that the CJ, former CJ, approached the president.
Really?
Through some two eminent Ghanaians in this country.
The Justice Torkonoo?
Yes.
Approached the president?
Yes. Through two eminent Ghanaians in this country. I will not mention their names because I don't have the authority to mention their names.
Yes.
Now, I think maybe you also know.
Yeah.
Now, what was it about? To ask her to retire or resign peacefully and can take care all those things.
Her entitlements.
When the presidency prepared all the necessary documents, That was when she went to court, at the Human Rights Court, and jettisoned everything.
So you're saying that based on the information
I
you
am
have,
the founder of the NDC legal team. Don't you know that?
Yes.
I founded it because of my mistreatment, my mistreatment by the Bar Association.
Yes.
I wanted it to rival the Bar Association.
So you're saying...
So I can confirm to you, I can confirm to you, whether it was legal or not. You are not talking about legality here. He's also talking about legality here. You said that could we have done something as if nothing was being massaged. Things were massaged. Things were massaged.
So you're saying that...
Give her the opportunity. She approached the president through these two eminent people, very high people.
That she should be giving
Instead of her
her...
losing all this, can we do anything to help her to just go with her benefit? It's about benefits we are talking now, isn't it?
Yeah.
Was anything done? I'm saying yes.
So is that to say that because she went
She
to
then went to court. Why? When you go to court, you don't to tie your people's hand.
Yes.
So let's make this very clear. The next thing I want to talk about is that once you are appointed an entity head, you are required to acquaint yourself with laws and regulations governing your office. You are supposed to do that. And I can tell you again, I got credible information. Georgina Wood, when she was first appointed as Chief Justice, when she was appointed as Chief Justice, she went to Gimpa and asked for a special training course. Just she alone, no. She didn't go to attend class like everybody.
Yes.
Because she said that all through her life, she's been a policewoman and a court judge. She doesn't know administration.
Yeah, absolutely.
So they designed a special course for her. And in this one, I can even mention the man's name. Professor Hoy was then at Gimpa. They did that for her.
I see.
That is preparing yourself to take over the office. So it is no excuse for you to say that, oh, it's the accountant who brought it. It's the what and what who brought it. It's no excuse. Or you don't know about it. It's no excuse. It is no excuse at all. I am of the view that because Article 17 talks about equality before the law, we shouldn't be making exceptions for some office holders. We shouldn't be making exceptions for people. Why is it that some people think that if a certain political persuasion applies Article 146, it's good? But if another political persuasion applies Article 146, it's not good. Where is that coming from? Where is that coming from? Charlotte Osel, Loretta Lamte suffered under this same Article 146. And indeed, as a judge, and Martin has said it, the bar is raised much higher than these other people we are talking about. You, because this Chief Justice would have presided over some of these things in her line of duty as a judge. Some of these malfeasance. She would have presided over them. True. So if today she's been faced with that, look, there were other things like a committee she set up to deal with an ICT director. That committee recommended a reinstatement of the ICT director. She disregarded it. I think they were talking about dismissal of judicial staff. She disregarded it.
Send the ICT director, deputy to Tamale,
you know
to
that.
Be in charge of bailiffs. Yeah,
you know that. It's in the report.
To be in charge of bailiffs. So a man trained as this ICT specialist is the deputy director and transferred because she didn't like the results or the recommendation.
The recommendation of the committee. So you see, the sins of Torkonoo are so pronounced that what we should be doing as a nation is asking ourselves these questions.
You say her sins are pronounced?
So pronounced. Look at the committee's work.
Well, but the likes of Kofi Bentil and the former CJ, Sofia Kofo say they are not grave. The gravamen of it is not that much to warrant the penal consequence of her removal.
Good. Let me ask rhetorical question. Paying per diem to your husband when she's not entitled, paying per diem to your daughter when she's not entitled, is behavior we should promote.
So you should ask it to refund.
I'm saying that we should promote it. We should all be doing it. I'm also at DVLA, National Road Safety. Should I be paying money to my daughters and my wife? Is that what you are telling me?
He's.
Nobody said that.
Yes.
And
No, I
so
don't think
Nobody said that.
that behavior is totally unacceptable. And in some countries, don't we see people going to jail because of some of these things? Haven't we heard in Singapore, a minister was given a watch? And what happened to the minister? Why do we always want to lower the bar for some of our people in this country? Why? When the former president, now president, met the NDC lawyers and talked about judicial reforms, he never spoke about removing the Chief Justice. Indeed, that comment came on the back of several rulings from the Supreme Court, which didn't sit well with most Ghanaians. Take the birth certificate thing. Take the Apenyo Martin ruling. Take the ruling that said that if you are presiding, you cannot vote. So after you preside, then you go and queue again and vote. All these Ghanaians spoke about. So that is where the comment emanated from. But was not about a Chief Justice. Was it the president who asked, what's the name of that woman? I'm told he's even an MPP man.
Oh, who?
The one who's this thing got the favor. The one who's petitioned. Daniel Foley. He's more lean to the MPP.
I don't
you don't know about that. You won't know because you're a journalist. So he's more lean.
I mean, no.
That's not your area. That's not your area. So I can forgive you. So he's more lean.
But you know because
I know. Yes. So he's more leaning towards the MPP. Was it the president? And I'm told he's a well-to-do person, eh?
Yeah.
Yes.
So, such a person, how can the president, railroad him to leave his business enterprises, follow money, do business, and come and write petitions? If not that, it is something that bothers him. So, I am of the view that what is happening now is a clear case for future Chief Justices to begin. And this is not one of the things you say that it's an attack on the judiciary. No. This is not an attack on the judiciary. An attack on the judiciary is when, by this time, judges' houses would have been cordoned off. Then, when they are going into their court, soldiers are there with guns, showing that they shouldn't give certain rulings. That, for me, is an attack on the judiciary. But removing one person...
As the head of the judiciary.
What if he collapses and dies?
She didn't collapse.
Now, what if that happens?
No, she didn't collapse.
Will the judiciary continue?
It will, but...
So what is wrong with one person who has been found to have misappropriated funds in this way, asked to step aside? What is wrong?
She's been removed.
There's not
They have to be removed. They have to be removed.
Here's what in the mind of the former Chief Justice, who is actually a member of the Council of State of your government.
Yes.
I mean, this administration.
Yes.
Sophia Kofo says this decision weakens the judiciary. Let's take a look at this exclusive interview that my colleague Joseph Akable had with her earlier in the week. Take a look.
I'm very sad about it. It has really saddened me. And maybe in a way, I feel very distressed by it. Yes.
In terms of the conclusion that was reached, where the matter has journeyed from, is the sadness as a result of the conclusion, or you have questions about the procedure that took place before that?
The sadness is about the whole process. My sadness is because as far as I'm concerned, it was a very unnecessary. We have been taken through a very unnecessary situation, and which, as far as I'm concerned, and that is my honest and candid view, this has so weakened the institution of the judiciary. It's not so much the individual who occupies their position. It is the institution. That is what I'm concerned about.
I mean, what informs the conclusion that it's an unnecessary process? I mean, we have heard even government spokesperson make the point that a petition was sent, a committee in line with the constitution was set up, they've looked into the matter and they've come to a conclusion. Which aspect of it, what specifically makes it unnecessary?
I think that, you see, there has always been something wrong with Article 146. And particularly with the procedure that it sets out, and especially as it regards the position of the Chief Justice. In the Ajay case, I took the opportunity to reflect on that weakness that I noticed, and are these and these are not. So to me, they lack the gravity. They lack the gravity that would lead to a grave outcome, such as the removal of the head of an institution of justice. I've deliberately phrased myself that way. It trivializes the position, and I wonder what this is going to lead to further on along the line, because every judge is fair game and every Chief Justice is also fair game.
I mean, is that to suggest that you suspect there could be a ripple effect in that?
Oh, definitely.
Any matter,
it's not suspect. I foresee. Not tomorrow, maybe not next year, maybe not in 5 years' time, but along the line, yes, unless those provisions are dealt with effectively in a revised constitution.
Maybe a more direct question. I have seen the letter that was written by the Secretary to the President, the former Chief Justice.
And that's the other thing. A warrant, a person holding a presidential warrant. That's what the position is. You become Chief Justice because you have received a presidential warrant. You can receive all kinds of letters that you are hereby appointed, but if you don't have that warrant, does that make you Chief Justice? Yeah, okay. So
That's the former Chief Justice of the Republic of Ghana, a member of the Council of State of His Excellency the President John Dramani Mahama, Sophia Akufo, in that exclusive interview with my colleague Joseph Akable earlier in the week. Amaliba says this has weakened the judiciary. It was an unnecessary process. In fact, this decision to remove her lacks the gravity, really, of an offense that should warrant such a penal consequence.
You know, the former Chief Justice was the one who presided over the prima facie determination of Charlotte Asare. You know that?
Yes.
So it was okay for Charlotte Asare to be removed on procurement breaches, which is not related to her work as an electoral commissioner. But today, she is saying that breaches such as this are not enough to remove the Chief Justice. And that's what I'm talking about, the way and manner in which we try to elevate judges above all else. If it was good for Charlotte Asare, it should be good for Justice Torkonoo. That will reverse rulings of the court. That, for me, amounts to that. Or government decides to withdraw funding to the judiciary and crippling it financially. That, for me, is the attack. The framers of this constitution did not put Article 146 in the Constitution for aesthetic purposes or for decorative purposes. It intended that one day a judge would misbehave. And Ajay has dealt with what amounts to stated misbehavior. I cannot see how we can allow a Chief Justice to continue to be in office whose penchant is to be giving contracts to his family members, give unauthorized per diem to his family members, and nobody sees anything wrong with this and says that we should allow it to continue. Would that be extended to me, the Director General of National Road Safety, to pay my daughters, to give them per diem? Will that have been acceptable? If it's not acceptable, it is not acceptable for her. And I don't see how anybody can look at this and say it amounts to executive interference in the work of the judiciary. I cannot see that. Are we therefore saying that it is a clean check for Supreme Court judges or Chief Justices to do what they want, because when you touch them, you touch the anointed? Is that what we are saying? Why? There are other Supreme Court judges in the Supreme Court. Now that nothing has come about them, who has spoken about them? Who has deliberately gone into their work and want to victimize them? It's unfortunate that this has come upon herself, and all excuses that she's given are unfounded. To say that I am there, then they come and give me a check and I sign, is not what an entity head should be doing. We should even be afraid that we have such a Supreme Court, Chief Justice in office.
How is that? I mean, why would you say that we should be afraid in this?
We are not saying that she's not competent. We are not saying that she doesn't know the law. What we are saying is that there are other responsibilities of hers that have not been, discharged by her to the glory of God. The Constitution stipulates that she has failed to live above the stated behavior principle. She has not been able to, as it were, conduct herself in the office so as not to be blamable. Should we leave such a person to be there because she's a good judge or because she's a woman? And I've asked the question, would anybody in this country say that what she did by giving money to her husband and her daughter is good behavior, and that if you have your child in school today, you would say, look up to Torkonoo, and when you grow, you also give money to your husband and your children who are not entitled? Would you say somebody to emulate her work? Would you? So if you will not do that, and a committee has been put in place, and the committee's findings is that she should be removed, how can this metamorphose into an attack on the judiciary? That is what I cannot comprehend. How is that an attack on the judiciary?
So you said this doesn't weaken the judiciary in any way?
Has Bafubon, who is acting now, said that he can't give judgments? Has Bafubon, who is acting now, said that soldiers came to his house and I've asked him to give a particular ruling? How is that weakening the judiciary?
So you hear I'm going to come to you, but you hear the former Chief Justice, now member of Council of State, say she's been reflecting on this Frank Ejechum case, and even though she concurred in that particular ruling, she's been reflecting on the weaknesses in there. And you hear Ansah Asare also corroborate that in the sense that putting together the sins that could cost the job of a justice of the Superior Court being the same sins that could cause the job of a Chief Justice may be not a fair approach to applying penal consequences, that there should be some decoupling of the penal consequence that would lead to the removal of a judge or a justice of the Superior Court, and then a different set of penal consequences for the Chief Justice if he or she misconducts him or herself.
My senior here is talking about judicial reforms. That does not apply here now and now. Judicial reforms, we can talk about it another day. But now,
Say the law is the law.
there's this one. So, and as for the former Chief Justice, that is an afterthought. Judges will tell you, lawyers will tell you, it's an afterthought.
Okay.
I don't think that she wasn't reasoning when she took part in the Jechum case. She was reasoning all right. These statements now are just, for me, solidarity for woman, a fellow woman, and those things. But I don't think that she actually believes in what she's saying.
Okay. Now, Bakubas.
MPP for ye den ekosro eba form edo mu konsi honom ewo mo nan a the law is the law and the law must work. What you say? The law is the law and the law must work in its accordance. Torkonoo hwan na enim no se Torkonoo oteso no na wo ye de opewo judicial system honom. Obi anim, this is an open secret. What you say? Obi anim se Torkonoo na odi eye judicial system honom aye eye ne fie asemba o kwan a obefa so adi no sebi nyado o sedi osika ne nsem to the extent say utie ne na Amaliba echechim na odi ne bakọ trip ema Ghana ye yitua ne ho sika esamba ebedi asem esandi in favor of ono sedi no esipe no. What you say? Esam bedi asem no sedi ono esipe no as a Chief Justice. Hwedi esi ye 2020 elections, right? 2020 elections. So I think say no, I know no. Okay, I know no. But okay, ye mami get to Torkonoo. Ye can kono na wa city precedents. Asem ko court anasa asem ko ye we a judicial system a or the way we see can ninsem anase Ghana ni etimi tena ni kurom, sorry, Ghana ni etimi tena ni fie e prejudice asem no anase yetimi ka se asem we dey say na ebeko ya ye nim ye nkosua law ye nim hwe kra no obenso bi di na adwen ebetena se ameki abe prejudice asem ni be wi achi no na the same thing the same thing and akọ. So it shows how clear this woman any MPP for na omobo because of say nanado and ye no as Chief Justice. Mami misa same way. Okay, MPP for say Chief Justice no ni omo afa. Adan na say omo ni abere ho din say NDC for abuse power omo abuse embrano and it shouldn't have happened. Maybe so. Someone say Torkonoo enya affiliated to MPP. Why then are you people defending her removal? More criticizing say the removal no, it shouldn't have happened. It shouldn't have happened. It is really sad. What you say? It is really sad. It is sometimes, you know. Me. It is sometimes, you know. MPP for help omo play on the minds of the people. But anything, any juma. Munin clear say Torkonoo ade ana oye no na oye in favor of mu MPP for enti no ene on say afanyo maake waye mobomobo spoiled child sebi ni maami wujana oye mobutu akwada sebi ni maami ene ni papa etiase a ombe hye ne tatwe no omonka na asem no saa akwada no sebi eburu sebi enyado se ne maami no ewu firi ho no ana se omu firi atiase fo asase so na se otiase a do you know what saa akwada no ne ho ye mobo ese nipa bia wa asase so ne ho ye mobo ese nipa bia and na asem so de oka enyezi ento hwe afenyo market na all this while amu share Supreme Court we ase no Chief Justice remove ano on say na waye basa because onim say honom na odwane kotoa honom na eyide pai so a okọ na odi ni nsem ekoto maame nim na maame no de ne powers eka bi ma no but ene oye hu hwenye yi ene oye hu hwenye yi dua bu abo no abusiafo enti we ye nsem a Alfred Okansi the panelist Asare osa na bibisa osas Asare bibisa any Amaliba any Kofi Bentil and I think say one panelist been so was so no mu ye 5 what you say almost submission ena omo da babo enti ba ohwe ne nsem Amaliba kana sa prima fashe bibi ne omo kan me nyanye lo nti mega masa eno de mentre baby menhwe me nseme me nyanye lo but you can attest to the fact say the decision na committee ni tinase a omo den omo lande ono na yewura John Mahama ejina so de yeden acti ye enti no anyo onu ankasa and besides Daniel Ofori na oni sa star ne ho ne keka ho omo di petition that 3 people no mo di petition cause so munyi maami na di no yewura John Mahama oni hu hwe Oni mohwe, he has no link with them. Otiri baby no waba eno although say dun katia ne bandi no mo ka say oh maami no de ebeyi no and those but kasa yem funama kasa den eyem funama eno no an kasa ni suban ene ne niye bi ena ama maami no anye den antena dwom into obi nka na omonka ma no ntum na ye nyina ye respect emra no because emra no Ayembra said the law is the law and the law must be the law. Nobody is bigger than the law. Neither nobody can challenge the law. Embrano who challenge na masa odubedi nti ene ma many challenge embrano oni nedi so wadwo comment section ma hanom ewia number 1 authentic platform Mega TV yankopon koso a inshira makra bye bye.